Good morning, everyone. On behalf of Young ICSID, we would like to welcome you to Young ICSID's online book launch series. My name is Daniela Arguello, and I'm a legal counsel at ICSID. As you may know, Young ICSID is organizing a series of online events to give young lawyers and law students access to information on recent developments and international law and ISDS. These events will be focused on newly published books, so stay tuned for more information. Today, we're delighted to launch Ms. St. John's recently published book, The Rise of Investor State Arbitration. Before we get started, since we're doing this online, we're going to lay out some rules for our online participants. So first, by default, please, all participants have to be muted. We ask you not to unmute yourself. However, we invite the participants to submit the questions in writing during the event. To do so, please send your questions through the message board on the right side of your screen and send those questions to my colleague Damon Visdumber rather than to everyone. We will address the questions as soon as the presentations are complete and in between. And with that, I would like to present our moderator for today's panel, the Secretary General of ICSID, Ms. McInerney.
Welcome to everybody. Wherever you may be, we are delighted that you decided to spend this time with us. And I'd like to first thank our panelists. First of all, Taylor St. John, who is the author of the book that we're going to be looking at today. Secondly, Antonio Parra. And thirdly, Sudhanshu Roy. Let me first introduce Taylor. I think a number of you may know Taylor or some of the work she has done. She is currently a postdoctoral research fellow at the Pluricourt Center of Excellence in Oslo. And she is also a senior research associate at the Global Economic Governance Program at the University of Oxford. Taylor's work is very interesting in that it focuses on the international architecture for resolving international foreign investment disputes, and she looks as well at the political dynamics of these kinds of agreements. She is also involved in a number of collaborative projects now that are quite interesting that revolve around investment dispute resolution in civil war contexts, gender in investment arbitration, which of course has become a theme very much in investment and in trade agreements of recent, and the role of secretariats in dispute resolution. So it's a very interesting, discrete take on this area of investment law and investment dispute settlement. Antonio Parra has been very kind with us, and he is probably very well known to you as he was with ICSID for more than 15 years, successively as a senior counsel, legal advisor, and deputy secretary general. He also has extensive experience elsewhere in the World Bank and as a legal counsel with the OPEC Fund for International Development. At the World Bank, Antonio also had involvement with MIGA, the Multilateral Investment Guarantee Agency, and also with the formulation of the World Bank guidelines on the treatment of foreign direct investment. And you'll see that that relates very much to what Taylor talks about and the various options that drafters and states were looking at in 1966. Finally, I wanted to introduce Sudhanshu Roy. Sudhanshu is an international associate with Foley Hoag, and he's based here in Washington. His practice revolves around investor-state arbitration, and in particular the representation of states under both the ICSID and the UNCITRAL arbitration rules. Before joining Foley, Sudhanshu worked as a legal advisor in the Department of Economic Affairs for India, and he was very much involved in the drafting and conception of the new Indian Model Bilateral Investment Treaty. He's also worked on negotiation of several other international investment agreements, and he will bring a unique perspective to the discussion as well. So we wanted to move now to a little bit about Taylor's book. It will be available to you, and I don't know if you can see this. Let me get this properly for you. It is both a beautiful book on the inside and the outside. What it does is it takes readers through the key decisions that created investor-state arbitration, and it draws extensively on primary research on the archives of the World Bank, archives of various governments, and extensive interviews with those who were involved. And I think you will find that this is an incredibly readable, interesting text. And what I found when I was looking at it is it really takes you into the time period where all of this was being discussed. And we might take it for granted what investment arbitration is and what investment law is, but it puts you in this new era where a number of very innovative people were thinking, what is this? Could this be useful? How does this fit within the broader mission of the bank? How does this fit within domestic policies for individual states? And you will start to understand a bit about the different positions and indeed the strategy behind pulling all this together. One of the things I found very interesting, Taylor, first of all, is that some of the issues that we see debated today were in fact considered in 1966 and have actually been returned to several times over and over again, things like appellate courts and that kind of issue. So it's interesting to see why certain decisions were taken initially, and they certainly inform our thoughts now. As well, I think it's really interesting to see that some of the most strongly held assumptions about investor state and ICSID, in fact, are not correct and never have been. The one that struck me was this whole idea that it's a complete accident that ICSID convention is used for treaty cases. In fact, as Taylor has looked at in her book, that was very much contemplated by the drafters. So they're another of these sort of popular myths that, in fact, were addressed quite early on, and I don't know how they became myths, but we have exactly the person here to deal with this. So, Taylor, over to you.
Great. Thank you to Meg for that very kind introduction, as well as for inviting me, and to Daniela and Damon and Young ICSID, and ICSID staff who are in the room. I'm really honored to be one of the authors kicking off this new series. I think it's a great initiative. And I'd also really like to thank Antonio and Sudhanshu. I am truly looking forward to your comments. So some of you will know this book started many years ago as my doctoral thesis at the University of Oxford, and both of you, as well as you, Meg, made time to answer my questions back then. So I've been learning from you all for a long time, and I look forward to learning some more today. And again, as Meg alluded to, and as we all know, it's an exciting time to be discussing the rise of investor-state arbitration. So I'm hoping that with our online audience, we can have an expansive conversation today, touching on both specific findings and evidence that's in the book, but also maybe drawing out some broader themes, and if those themes can help us understand some of what's going on today. The book is driven by a single core question, and that is, what explains the rise of investor-state arbitration? And I'm interested in intellectual, political, and economic forces. And to the extent that investor-state arbitration had founding fathers, and I think it did have some founding individuals, what constraints did they have? What motivations? What was their thinking? And as Meg said, the book is based primarily on documents from the American, British, German, and Swiss archives, as well as some documents from the World Bank, New Zealand, a couple other archives that I found useful. And in compliance with a slowly emerging Mauritius Convention style norm for scholars, I put all the documents that I could in a qualitative data repository, where they should be available to everyone online. So I want to show you a few of those documents today to really try to, again, make the world these officials inhabited slightly more concrete. But before I get to that, I want to give you a brief overview of what's in the book. So after the introduction, the first chapter starts with political science theory about how institutions emerge and how they change incrementally. And then Chapter 2 identifies what I think are some core antecedents of the ICSID Convention, both enduring controversies in earlier centuries, as well as what I think are more hopeful steps toward international cooperation. And then Chapter 3, which might be my favorite chapter, I love them all, but I think Chapter 3 is my favorite, is about how national officials saw their options in the 1960s. And the first bilateral investment treaties, multilateral proposals are in there, but it's really about the individuals and the political forces that are driving these initiatives. And one of the things that I was the most surprised to find were the number of connections there are between the Second World War and investment law. So the personal experiences of people like Aaron Brockes, who left the Netherlands in 1938 just before his family's business was expropriated, or Herman Abs, who has no connection to ICSID, but is important for investment law, who helped lead the expropriation of Jewish-owned property for Deutsche Bank. and others. So these personal experiences matter, and they play out, I think, in interesting ways. Chapter 4 then turns to World Bank officials and why they decided to draft and sponsor the ICSID Convention and their strategy for introducing it to states, because this is no ordinary intergovernmental negotiation. This is something very special and new. Chapter 5 evaluates how states responded to the bank's proposal for the ICSID Convention, and I'm excited to think Sudhanshu will pick up on some of the findings from Chapter 5. Chapter 6 then documents how investors' arbitration clauses were integrated into investment treaties and the forgotten role, I think, of World Bank and ICSID officials in this process. And ICSID, as everyone in the room knows, did not have a case for 8 years. So those early years tend to be overlooked, right, when we tell the story of ICSID. But to me, those are really crucial and very interesting years. Chapter 7 then charts the evolution of U.S. government thinking on arbitration from 1966 to 1993. And Chapter 8 is a very short chapter which just probes the political and bureaucratic obstacles that officials sometimes perceive to reforming or changing their investment law obligations. And then the conclusion felt very speculative to write, given sort of what's happening right now, but it examines two visions for the future of investors in arbitration, one sort of fully private, one fully public, that are kind of ideal types. But again, that conclusion may look very silly in 5 years. We'll see. So that's the overarching summary, but now let's look at some real documents. Today, in my comments, I just want to talk about 2 episodes, and first is the early 1960s. So in the 1960s, officials discussed 3 different multilateral initiatives for investment protection. They discussed insurance, a multilateral code, and then a standalone arbitration or dispute settlement fora. And I think investment insurance was actually the best known among investors. And I think in the early 1960s, it looks like a multilateral insurance agency would be created soon. So this on the screen is an American document noting that an expert OECD report said an insurance agency posed, quote, no insurmountable legal or technical difficulties. And then this document, which is from Swiss officials, who are reporting back from the OECD, is equally optimistic. It notes that there's strong support from several countries, and sensationally, it says, America was willing to lead on a multilateral insurance convention. So then in 1965, the OECD Council sent the World Bank a report which outlined a multilateral insurance scheme that they believed would receive wide support. And the proposal is really interesting to me because it had resolved the key distributional hurdle to insurance, which is that OECD states had agreed in principle to a loss-sharing formula. So the World Bank was tasked with preparing a draft charter, and from the outside, it looks like multilateral insurance would be a go. So then why is it that an insurance agency was not created at the bank in the 1960s? And this document from 1961 it's in German. It's written by the German executive director of the World Bank back to officials in Bonn. And it's recounting conversations where European and American officials are enthusiastic about insurance, but the relevant World Bank officials, and one official in particular, Aaron Brockes, who is then assistant general counsel at the bank, seems to believe that the bank should not become involved with insurance. This is what the German official is reporting. And that German official is perceptive. He's right. Brockes did not believe that the World Bank should become involved with insurance. But the question is, why? So in this interview, which is from much later, Aaron Brockes says, quote, the statistical value of insurance can't be proved. And he also says, quote, I was the one who felt most strongly that the bank shouldn't be in a position where it is both an insurer and a lender. And what's interesting to me, and what makes me speculate that there might be something more to Brockes' thinking here, and maybe Antonio can give us richer personal insight, is that, I'm counting on you, is that Brockes, who, for those of you that aren't as familiar, is sort of the father of the ICSID Convention. He's the first and the long-serving Secretary General of ICSID. Brockes doesn't really seek out statistical evidence for the value of ICSID, nor does he see it as improper for the bank to stand between investors and its borrowers when disputes are resolved through arbitration rather than through insurance. But in any case, insurance, which I think is arguably the dominant or most talked about option in the 1960s, does not emerge then. The second option, which is I think more familiar probably today is the idea of a multilateral code, and this can be combined with a court or arbitration depending on the draft. And there's the common belief, I think, in sort of core investment law classes that investors push this multilateral code in the 1960s. And I think we'll see what the rest of the panel thinks, but I'd like to revise that slightly, because I'm not convinced there's really widespread investor interest in the ABS draft, which becomes the ABS-Shawcross draft, which then a modified version of that becomes the OECD draft. I think it's more a few extraordinary individuals who have personal experience of expropriation that are really pushing this initiative. And at the center of this group is Herman Josef Abs, who I mentioned earlier, who was probably the most experienced expropriator and expropriatee in the world at that time. And he leads the drafting, but also the kind of transnational lobbying on this code. And you see these two speeches here are both in English. One is to an American audience, one is to a British audience. So he's doing a lot of work. And there's a lot of scholarship from Mona Pinchas and others that's coming soon on this era. So I think we're going to learn a lot more. But what I want to highlight today is just two reasons why the OECD draft never got off the ground. Because I think we have enough evidence now to correct some misperceptions, let's put it that way. So first, over time, an impression has grown that OECD states could agree to this multilateral investment treaty. It was just developing states that caused problems. And not everyone believes this, but it's a belief that's definitely around. And I think, on the contrary, the standards in this draft were controversial within many OECD states, capital exporting OECD states and capital importing OECD states. It's really disagreements within the OECD that kill this draft. And so this document, I don't know if you'll be able to read it, but British officials are stating that their government cannot comply with several standards in this draft, such as free transfer provisions. And they find arbitration to be a particular non-starter. So in 1958, British officials discussed the possibility of their government being sued by German investors, and they recoil, right? This is their political nightmare. And it's not just the British. The support of many OECD states is considered uncertain at the time, and America is particularly strongly opposed. The stated reason in this 1961 position paper is because developing countries are not in the room. But I think behind that stated reason, there are strategic Cold War concerns, and there are also domestic political obstacles. The Americans among you will know that senators like Burke Hickenlooper were taking an extraordinarily unforgiving line on expropriation at this point in time, and U.S. officials knew that they couldn't secure a multilateral treaty that would satisfy Hickenlooper. But there's another reason that the OECD draft fails, and I think that's because European governments stopped supporting the OECD draft when they realized they could get stronger investment law standards in bilateral treaties. So in the scholarly literature, there's sometimes an impression that it's only after the OECD draft collapses that governments really start to get serious about negotiating BIPs. And I want to suggest that it's the opposite. I think the draft collapses in part because its main supporters start to prefer BIPs. And this slide, again, probably can't read the text, it's in German anyway, shows the evolution in the Swiss position from preferring a multilateral approach in 1962 to later calling BIPs better than the OECD draft and requesting an end to multilateral discussions because those were weakening the Swiss position in BIP negotiations. And then in 1962-63, Germany, France, Britain, and America actually go and consult developing countries on the OECD draft versus bilateral investment treaties. And as you can tell from this table, they learn a lot, including that some countries are willing to agree in bilaterals to things that they wouldn't necessarily agree to in a multilateral setting, or for political reasons they prefer bilaterals. So the prospects for a multilateral agreement are never good in the 1960s. We might say they're not so great after the 1960s either, but we'll see. Nothing emerges then. Okay, the third option is a standalone arbitration organization, and as we all know, this succeeds, right? This is the organization that we're sitting in today. And Brockes himself, this is interesting to me, he calls it the third approach. So this is an interview from 1984 where he calls it that, but also in speeches as early as 1961, right, which is much earlier than we tend to associate this idea. He's saying it's not the code, it's not insurance, it's more feasible, right? We can actually get this done. And we remember Brockes today as a skilled lawyer, as a fantastic diplomat, who understood the political landscape that he faced well enough to see that arbitration could be feasible, and I think to make it a reality. So Brockes is a person who I think frames investor-state arbitration within the broader mission of the World Bank, associating it with additional investment and other benefits. Should I keep going?
Keep going.
Okay. He ensures that the ICSID Convention was written in a way that someone like Burke Hickenlooper could agree to ratify, as well as leaders of newly independent states. And he introduces the ICSID Convention to officials in a carefully designed consultative procedure that makes it difficult for the drafting to be derailed. But I think there's another aspect of Brockes' work or his vision that he doesn't get much credit for, and that, again, as Meg suggested, is investment treaty arbitration. So this is a 1960 UN report which says that if an arbitration organization at the bank were created, it could serve as the fulcrum around which substantive bilateral and possibly multilateral agreements could be drafted. And this report is not written by Brockes, but British notes tell us that it was drafted after conversations with him, and my sense is that it reflects his thinking. And I also found a 1961 American Bar Association draft convention that proposes an arbitration center at the bank, which again was not written by Brockes, but was drafted after conversations with him and also with Georges Delhomme, who worked at the World Bank legal division for many, many years. And this draft mentions treaty-based consent explicitly. So I know that Antonio is going to discuss, I think, both of these documents. So I will only say here that the idea, again, as Meg said, this wisdom that in investment treaty arbitration was sort of unforeseen in the 1960s, I think that's misleading. I think Antonio and I both agree that there's a lot of evidence showing Brockes and others have a vision of contracts, of domestic laws, but also of treaties giving access to ICSID. And they have this vision before and during, as well as after, the draft of the convention. Where I suspect I might go farther than Antonio is to argue that Brockes not only understands treaty-based consent, but that he does more than anyone else to make treaty arbitration into a reality. So this process of adding arbitration clauses to treaties is the second episode that I want to discuss today. And in the book, I frame this pretty provocatively, and I ask, would arbitration clauses have been added to treaties without the initiative of Brockes and other World Bank and ICSID officials? And of course, we can't know the answer to that. We can't go back and do that time period again, but I think there's enough evidence to at least justify asking that question. The world's first bilateral investment treaties do not contain investor-state arbitration. Of course, right? These are the German notes from February 1959. This is as they're drafting, they're discussing the world's first investment treaty. And German officials in this process meet Hermann Abs' deputy, who is a lawyer. Hermann Abs is not. His name is Paul Krebs, to discuss Article 8, which is the dispute resolution article of the German debt. And the official in his notes from that meeting say, quote, Dr. Krebs deemed it essential that this access is not only open for states, but also particularly for private persons. And then a month later, that same official writes, the wish of Dr. Krebs to enable private individuals to appeal to arbitration judges cannot be satisfied. So German officials discuss adding arbitration to their treaties, but then they decide that they cannot or they don't want to. And the reason that appears in the official documents is that individuals don't have standing at the ICJ, which suggests that without the ICSID Convention, German officials, who were very, very expert, did not see how to add individual standing to their treaty. Now, I'm sort of skeptical of this being the only reason why the German government did not want to add arbitration. My fantastic research assistant, Janek Stiller, and I read a lot of documents, and in some of these documents, there are other concerns that are brought up. So some in the German government thought it might create diplomatic liabilities to empower their investors with standing, which again is very different to how we think of that now. But remember, at the time, West Germany is really working hard to avoid any action that would be perceived as aggression in the 1950s. But we also found that some officials within the German government emphasized that they don't think that German investors really want or care so much about having access to arbitration. They care about other things. And so this document reports from the International Chamber of Commerce that there was a survey of investors in 1962, and no German investors apparently responded that they thought arbitration would affect the investment climate of a country. And to me, this ICC survey it's important because it underlines or suggests the extent to which private sector interest in arbitration at that point in time, certainly not today, but at that point in time was really a few exceptional individuals capable of attracting a lot of attention, but it wasn't really a widespread movement among investors. So in my reading, governments and investors might not have inserted arbitration into their treaties or might have done it much later without the World Bank's guidance. And of course, a lot of the intellectual and legal lifting to make investors arbitration into a reality is done by ICSID and World Bank officials. So Paul Tsaz, an early ICSID staff member, wrote this model clause document which showed states how to provide consent to ICSID in investment treaties. There was a document for contracts, but this was the treaty-specific document. And before this document came out, treaties don't provide access to arbitration. So it comes out in 1968, and Brockes then, I think he disseminates this document for decades. So it's possible to trace his travel schedule and then which countries added arbitration into their model treaties. Brockes, of course, makes a lot of visits to national capitals that don't result in any such clauses. But I think the appearances in Dutch, and then Italian, and then Belgian, and then French, and then British treaties, those are all preceded by conversations with Brockes. And I should add a footnote here that there is one treaty, and Tony's going to pick this up, I think, that is a Dutch-Indonesia BIT, and it includes a clause that mentions access to ICSID that comes out before this document. I think there are reasons to believe that Brockes had conversations with both governments, but we can leave that aside.
He told the Dutch to correct their text after they adopted it.
Yes. So, the broader point here is that Brockes and the ICSID Secretariat are not just aware of the spread of bilateral treaties with arbitration access, they are, as this annual report, the one on the right, notes, quote, assisting member governments and investors in setting up the provisions for consent. And the number of advanced consents becomes the benchmark for success at the Secretariat in those early years. Again, this is in the absence of cases, so it makes a good benchmark. And I think it's important to note here that it goes beyond treaties. So Brockes also initiated a large project to catalog domestic investment laws and to assist governments in providing consent to arbitration in those domestic laws if they wanted to. And I think that's work that continues today in other parts of the World Bank. And I know Antonio was involved with this for some time, so I'm hoping that maybe we can speak about that in the discussion. But I want to highlight two more things. The first is that Brockes recognizes that before there has been a single investment treaty arbitration, Brockes recognizes that BITS create the potential for ICSID to have an enormous potential clientele or an enormous potential caseload. So again, this is more evidence of kind of an understanding of treaty arbitration. It was just a long time coming. And I want to end with this slide, which is one of my favorites. This is a letter from Brockes to an official in New Zealand that he had met at a conference. I was following up and reminding him that he had promised to, quote, give ratification a little push. And I think it's a nice summary because states made the decisions to ratify ICSID. They made the decisions to insert arbitration into their treaties. But Brockes and the Secretariat were there at key moments, clarifying their options and reminding governments to push in this case. And I think a lot of times these smaller actions, these reminders, don't attract our attention because we tend to focus on the big negotiations, on the moments like the one we're in today. But if we take the long view, these small actions can accumulate over time and they can be transformative. So I think when it comes to constructing the architecture for arbitration, the rise of arbitration and treaty arbitration, I think the work of this Secretariat, in those early years was crucial. So thank you, and I'm really looking forward to the comments from others.
Tremendous. Antonio, I wonder if maybe you have some thoughts and a perspective on this that you could share with us.
Well, there's so much to say, and one thing in particular is I think that this is really a wonderful book, and one that, at least from my perspective, opens up a lot of new vistas and perspectives. Normally, when one thinks about ICSID, or when this one thinks about ICSID or writes about it, you're looking at material emanating from the institution and speaking in a broad manner, so not just ICSID itself, but also the World Bank. And this is such an eye-opener to read about reactions of governments from within their own archives, to have, just off the top of my head, to read a quote from UK government archives, something to the effect, well, there's no interest in this thing, or whatever it might be, and you think, wow. So this certainly wasn't, these certainly aren't viewpoints that we were exposed to long ago, and even until recently through Taylor's book. So I think it is very a valuable resource. I have a number of different points. I don't know how I can keep up with them all. It's such a wealth of material. One thing Taylor mentions in the book, and I think it's true, is that there was, if you look at the ICSID process from within the bank, there isn't a lot of sign of investor activity or pressures or lobbying or even any input at all. And you might wonder where that half of the equation is, if it ever was anywhere. And I think one of the points when you think about ICSID's early history is to remember it progressed in quite different stages, one fairly compartmentalized from the other. So you had the Ab Shawcross effort, which was a private sector effort led by an advisor to Shell Petroleum, namely Hartley Shawcross, obviously a big investor, and the head or top person in Deutsche Bank, which is obviously another big investor, and their little study group that they set up in Geneva, AAPPI. Mm-hmm. This was all sort of investor community people. So I think it's important, or at least useful, to remind oneself of that. In regard to the Shawcross draft, the link, it's not just that it was a substantive code, a code of substantive standards of treatment of foreign investment. It had an annexed to it dispute settlement provisions, state to state and optional investor state. So the whole package, from say 30,000 feet up, it's like a bit. Now, a fairly short treaty with substantive standards of treatment and dispute settlement provisions. And what happened was, or at least my reading of what happened, is that it was fairly early on concluded that the larger code of substantive standards of treatment, that wouldn't fly. And so the dispute settlement part was shaved off of it, and that did fly, as Taylor points out. But a very interesting observation Taylor just made in her presentation that I hadn't really thought about too much before, and I suspect it's very correct. Taylor said that the larger code of conduct was doomed to failure, at least in part because all the developing countries were cut out of the process. It was strictly an OECD process, and that even at the very time was seen as a sort of near fatal weakness of it. But Taylor also points out that the industrial countries that were members of the OECD were not attracted to the idea that they might be at the receiving end of claims. And this, to me, is, we see now that this has been a recurring theme over time. In the mid-90s, the MAI within the OECD failed in large part for that reason. And now we hear TTIP is probably in trouble because of that point, and maybe NAFTA as well. And I think this is a real eye-opener to thinking about these things. These mechanisms don't seem to fare particularly well in that north-north setting, or at least historically they haven't. Taylor also mentioned this UN report, which I think is really this 1960, or was it 61, 60 report. And that report, as I've been able to, I think, maybe incorrectly, but I think the sequence of events was that the then Prime Minister of what was then Malaya gave a speech in which, this would have been in the very end of the 50s, calling for the elaboration of a code of conduct for the treatment of foreign investment, because he saw this as a powerful inducement for increased flows of private foreign investment. He was talking with respect to his own region, but the point is easily transposed to other regions. And that, in turn, led to these studies within the UN, of which this was the first one, examining different ways of promoting private foreign investment. And the options examined were the familiar ones now of investment insurance, code, and arbitration agency. And with regard to the code, the UN report was saying this is too controversial, and it's very unlikely to succeed. And now you mentioned that, and it is fascinating to read this. It's not very long, I promise you, but it's fascinating to read the report, because you're thinking, gosh, whoever wrote this has got such foresight. I mean, it's amazing, because things played out very much as outlined in that report. Yeah. And I wondered who wrote it. Now, you suggest that it was sort of the gray eminence behind it all was Brockes. Maybe it was. I wonder, it might be worth looking into. I think the legal advisor at the UN at that time was Oskar Schachter, who was very well known to Brockes and was a wonderful international lawyer. I mean, when you read that report, whoever wrote it is very, very well informed. And I just wonder if Schachter had anything to do with it. You mentioned that it was called the Bloch Report, and I think I unearthed the trace somewhere that there was a fellow named Bloch in the UN Secretariat then, but I didn't see that he was a lawyer. Not that a non-lawyer can't write this, but I had the impression he was on the policy side. But I think it might be interesting and worthwhile to look into. But at minimum, that report repays, and the follow-up reports repay reading. For example, Taylor brought up the slide where this observation had been made in the report that if we set up an agency, it can be a sort of forum for concluding further bilateral investment treaties. Well, I think, if memory serves, a subsequent report said, if we set up that agency, the arbitration agency, its accumulated decisions might create jurisprudence in this area that will effectively give us the code on substantive standards that we're looking for. And that avenue, I think, has been pursued to a very significant extent. Just very quickly on investment insurance, when you think about what was going on when the ICSID convention was being written, Brockes and his legal department colleagues were at the same time writing a forerunner of MIGA. So that was called the Triple IA, the International Investment Insurance Agency. And that went through a process quite similar to the ICSID convention and several drafts, but it didn't garner enough support from the member countries, and at the end in 1973 the bank management pulled the plug on the work and didn't take it forward, but that work itself was resumed 12 years later with the MIGA work, which did, as you know, result in an insurance agency. But I think in that regard, I don't know. I mean, the stories I've read have always been to the effect that there just wasn't enough interest in member countries to support the idea. I suspect, though, that you're right, Taylor, that the bank's management, including Brockes, their approach to that initiative was always rather lukewarm. And they just, this sort of initiative, a crucial ingredient for it to succeed is a lot of backing and enthusiasm for it from the Secretariat, from the bank itself in this instant. And it wasn't there until Shihata came along and really gave the investment insurance thing a push and had his staff staying up, not getting any sleep and working on it and persuading governments in much the same way as you showed Brockes lobbying for ICSID. And so I think that was an important part of the eventual success of MIGA and an important part of its initial failure. There's the absence of that very thing. I have one more thing to say, but I will save it for later because I've spoken too much. Thank you.
That's great. Thank you very much, Antonio. Sudhanshu, maybe we could pass to you at this point. You were going to give us a bit of a different perspective, and we've talked a bit about developing and developed countries and different perspectives. What's your thoughts on Taylor's research and the book and how it applies currently?
Well, thank you, firstly, Meg. Really, I'm very grateful, to Young ICSID, to ICSID, and Taylor for this opportunity. And I'm aware that I sit on a very, very distinguished panel, and I will try and live up to the expectations of, their remarks, which I thought were fantastic, and which would provide us with a completely different perspective on. And especially, coming from a legal background as a lawyer, it completely provides a different perspective on the work that sometimes we do beyond the cases. So with that said, I would also, before I move on, I would also congratulate Taylor because as part of preparing for this, I wouldn't say that I prepared a lot, but as part of preparing for this, I did actually, read substantial parts of the book, and it's a remarkable piece of work, and it's everything that probably a lawyer, who is writing a book on ICSID could never have thought or done, I'm aware that there is terrific work coming in. Behind the politics and the economics, the behavioral economics of investor-state arbitration and the rise of BITs, and I think Taylor's book is, a very, very important contribution to that. And it is also, as I said, as a lawyer, it is sometimes important to just think about the work that we do, think beyond the cases that we work on, and also particularly for me, especially, I would say that this work is important because it provides people who have a government background and who've actually worked in bureaucracies in various parts of the world, provides an insight into government decision making. It provides an insight, into why governments make the decision that they make, and it also provides an opportunity actually to rectify some of the past, I wouldn't say mistakes, but review what you've done in the past and take course correcting measures in the future. So with that said, and I would probably now move on to my remarks, which I will keep very brief considering the amount of time that I think we have, and also the fact that I think we'll have questions to follow. So the way that I want to structure this is, and I've picked this up from Taylor's book actually, is to talk about a few myths that surround how should I put it, the interaction between developing countries and investor-state arbitration in general, and also ICSID in particular. So I would like to talk about some of those myths and popular perceptions that exist, which probably may not be true, if one were to actually, look beyond, read between the lines, and read books and read accounts that come from books such as Taylor's and some of the other work that has been done in the past. But before I do that, as a preface to my remarks, I would say that Taylor's book makes this point very well, that the role of developing countries in investor-state arbitration in general and in ICSID in particular is very, very important. I mean, I don't think anybody would disagree with me. Obviously not Taylor, because she's written a book on it, but disagree that the success of investor-state arbitration and the ICSID, as an institution, was and is dependent on, the participation and the involvement of developing countries. So this is a point that she actually makes in the book a lot, and people like Broches and people who were drafting the ICSID convention at the time in the 60s were also probably aware of that. And I would urge you to read particularly chapters, I think 4 and 5, which talk about how the success of the first part of the project, which is creating the convention, was actually dependent upon measured or dependent upon its acceptance in the next phase by capital importing or developing states. And that's number one fact. And number two is we'd also prefacing my remarks, let's also acknowledge the fact that ICSID has done remarkably well in terms of attracting developing countries. So probably there is not much for me to speak, because there are 160 odd states out of 182 World Bank members which are members of ICSID, and probably almost every country, barring of course a few exceptions, are members of ICSID. So considering that fact, ICSID has done remarkably well. I mean, some of the countries which are not members, and which people would probably want to hear more about in the discussion that would follow, or even later. South Africa, I mean, the only country that I can find out, obviously, except, I mean, my own country is not a member, India, but the countries that I saw, developing states which are not members, the major ones, I'm sorry if I leave out, some of the, I don't include everyone. South Africa is not a member, Brazil is not a member, Vietnam is not a member, Iran is not a member, certain countries like Russia and Thailand, I don't know whether you can call Russia a developing country, probably, but they have signed the convention, but they have not ratified it. So that's 6 countries. Mexico just signed the convention in January, so which is again a remarkable achievement. And so that's just 6 basically, major in terms of major countries. And then we also have certain countries like Venezuela, Ecuador, and Bolivia, which were members, but with denounced the convention for various reasons, including political reasons. So that's the acknowledgement of the fact that ICSID has done remarkably well. So, so just borrowing on from that theme, why it has done remarkably well, I would like to pick up on that theme, and rather than talk about, give you the reasons, I would like to talk about a few of the popular, misconceptions that, go around, in investment arbitration circles. And also, coming from my own experience, I think these are myths which are probably, not true, and which also form a part of Taylor's book, broadly. So the first one that I would like to highlight is the myth that, Western countries, the so-called capital exporting powers, relied on these asymmetries in international relations and power structures to get developing countries to sign the convention. This is a myth which is very, very prevalent, and I'd speak from my experience, not as a lawyer here in DC, but, as a lawyer for the government. This is a myth that is very, very prevalent in, our part of the world, in Asia and South Asia and Southeast Asia, that, we are these small and poor countries which were, probably at gunpoint or something. We were all forced into a room and, given the deal that if you sign this and if you don't sign this, then you don't get like $20 billion in foreign aid or something like that. Something very outrageous. But that's probably not true, which I think is reflected in Taylor's book remarkably, in a very lucid and a very, a helpful manner. And this is not to discount the fact that there was initial, resistance from developing countries to ICSID. She talks about the Latin American resistance led by Chile, the NUR de Tokyo, that whole episode. But without going into that, what comes across to me, as a observer, is that rather than external imposition, signing of ICSID and, accession to ICSID, becoming a part of the ICSID movement was concomitant and was complementary with, domestic reforms in investment law that were taking place in a very widespread manner in those 70s and the 80s and the 90s. So this was not something that was imposed, and which comes across from my own experience in South Asia as well. I'm aware that, for example, countries like Bangladesh and Nepal, and obviously India has not signed the ICSID convention, and I'll come to another myth about why seeing ICSID, the ICSID convention and the ICSID movement and bilateral investment treaties as independent movements is sometimes not a very accurate perception. But the long and short of it is that this was not something that was imposed. Taylor's book cites instances where countries like Nepal and Philippines, I don't have all the documents, but from reading the book, it seems like countries believed that signing up for the convention would actually, increase capital flows. And many countries believed that, this would complement the domestic reforms that they were undertaking. And as they began liberalizing their investment regimes at home, they started signing, they started acceding to the ICSID convention, and this included the Latin American countries obviously were initially opposed to it, but in the 80s with the debt crisis and everything and the reforms that were taking place at home, I think this is a whole part of that movement. The second point that I want to talk about is the fact, which I had just mentioned, that ICSID and BIT movements are somehow separate. And I think Taylor's book, and she can obviously correct me if I'm wrong, and Antonio too, obviously, is the fact that ICSID is somehow a multilateral movement which is independent and which exists completely in isolation from the BIT movement, which I don't think is true, and which is very obvious from the fact of the broader theme of a book, that this the whole idea about ICSID was that you first create a convention, and then so that was the first part, and the second part was that you get states to give consent to the convention in the form of treaties, contracts, and changes to domestic laws. And I think, and this may require a whole new level of study, but I think, based on my experience, which is limited, but I think that ICSID and the whole growth of the ICSID movement and the ICSID convention did also complement the the BIT process, not just for countries which signed the ICSID convention, which is obvious, which comes from a book, but also for countries which are not members of the convention, because there was this whole idea that Taylor talks about, and which is very obvious, that state consent is only possible through a second layer of consent in BITs, and then the ICSID secretariat and the officials that were working here went about eliciting that consent through drafting model clauses, interacting with states, and I think at some point she talks about how this consent to ICSID seeped into European BITs, and I think that was very, very important, because a lot of the initial investment treaties were signed between European states and developing nations. So that, and when countries like UK and Germany send you and exchange drafts with developing countries from Asia particularly, they have this automatic, or how should I put it? I mean, the idea that the second layer of consent it already exists in the in the draft treaty. So that actually I think spurred on the BIT movement, and it was complementary. And I don't think that it's very it's inaccurate to say that the rise of ICSID and the rise of ICSID movement is synonymous with the rise of investment treaties in general. And the third point that I want to make here is that I think, and this also is a very overarching theme of the book, but the third point that I want to make is that there is a popular perception, there's a popular understanding that developing countries saw ICSID as some sort of multilateral agreement, that was again imposed on them. I mean, the idea that it's a multilateral agreement, I mean, technically that's correct, because there's no doubt that this is a multilateral agreement, and you have this repository, and but I think the idea that you could separate substance from procedure, which is again a very broad theme of the book, and the ICSID convention is only procedure, and it's the states are free to develop the substance in their in the form of bilateral investment treaties, and through their, I mean, do as they please as to the substantive standards. That was a very, very brilliant idea, in which I think obviously even now we see that UNCITRAL seems to be like borrowing from the working group, seems to be borrowing a little bit from that idea. I don't know how successful that will be, but I don't think that this was sort of a overarching multilateral convention, because of the fact that you had substance and procedure separated, and then you had the second layer of consent, which only came in through investment treaties. So, and I think that this idea that this is not like when you sign up to ICSID, you don't sign up to what fair and equitable treatment is, and what what non-discrimination standards you agree to. That was a very that was a brilliant idea, because that enabled ICSID to the secretariat to sell it, and to present this idea to developing countries. And then I mean, it's just the fact is the point I'm trying to make is that this was just an institution, a facility. The idea that was sold was that this was just an institution, a facility to settle investment disputes, and only regulate the procedure for settling those disputes. So this was not some sort of a multilateral convention. And why I also make this point before I forget is that, at the same time, if you see, during the 80s and during the 90s, even the 60s, I think Taylor talked about the OECD convention, the OECD draft. Developing countries did try to negotiate a multilateral convention, but they failed, and ICSID did not. And I think we need to understand and we need to look at why. And I think it can only be because of the fact that the multilateral convention failed because of several reasons. I mean, the multilateral convention on investment, this is the 97 convention that I'm talking about. It failed because of several reasons. One was that there was this whole idea that the substantive standards were being agreed. The second idea was that this was primarily coming from OECD countries. So ICSID was able to put aside these notions, because firstly it separated substance from procedure, and secondly ICSID also the World Bank was able to successfully advocate the point to developing countries that the World Bank is a global institution. And all the criticisms that come in of the World Bank are probably much later, after the 90s, or probably in the last 10-15 years. But they were able to sell this idea and advocate this idea that World Bank is sort of a post-World War II neutral institution without the historical vestige of colonialism and things like that. And therefore, I think I think that's where ICSID was successful. Now, the fourth point that I would, and this is the last one, because I have a couple of others, but probably they're too technical, and I don't want to make it like a legal panel or something like that, because this is a very interesting discussion, and I think we should focus on that. The fourth and the last point is that Taylor makes this point in her book that the role of international officials is often ignored. And similarly, I think in terms of if you look at the actual process of accession to ICSID and the spread of the BIT movement, the second part of the second theme of her book, I think sometimes the role of people don't talk enough about the role of bureaucrats in the developing world, and the connections that the bank and the bank officials were able to establish between bureaucrats who are working in foreign ministries and finance ministries, and and the World Bank itself. So I think that's an idea that is somehow ignored. Obviously, the reasons and the behavior. I'm not talking about like the behavioral economics part of it, which is why did the bureaucrats take certain decisions that they did. I mean, that's probably a different area of study, but I think that role is often ignored. And speaking from my experience, especially in South Asia and especially in countries of the British Commonwealth, I think this is very important because also of the fact, and this is something that I've done a lot of research in, and is also because of the constitutional status of international law in our part of the world, where a lot of discretion and where a lot of responsibility is left with the bureaucrats, because for instance, unlike the US, international law and treaty making are not necessarily parliamentary functions in our part of the world. A lot of it is left with the executive government. So for example, in most countries in South Asia, to sign a BIT or even to accede to the ICSID convention, you don't need parliamentary approval. All you need is the bureaucrat to draft a note, justify the proposal on policy and financial grounds, and then put it up to like the highest ministerial body, which is a homogeneous body, which is completely unlike a parliament where there is diversity of political opinion, and just put up the proposal to the highest ministerial body, which just approves it, and that's it, and treaties are done. So the role of bureaucrats should not be ignored, and I think that requires probably another study, but I think that has helped a lot in spreading the ICSID movement in in developing countries and especially British Commonwealth countries. That's it. Thank you very much.
Thank you. We have a few questions that have come in from our audience, so why don't I start with those? And they're obviously open to any and all of our commentators. The first is a question from Nicholas Alarcon, and his question is do any of the speakers have a comment on how the movement towards greater space for regulatory powers and state regulatory powers of recent, and in fact the inclusion of what might be considered non-investment considerations in recent treaties has actually started to contribute to broadening the jurisdiction of these tribunals? And do we think that this is actually going to change the nature of investment treaties into some kind of a broad investment instrument? And what would be the risk of this? And maybe does that mean ultimately that these become little ICSIDs in and unto themselves, or arbitral institutions in and unto themselves? So I don't know if any of you have some thoughts along that line. Taylor, any thoughts?
Yeah, I mean, that's an excellent, a very important question. I'm not sure if I have the answer to it, but I think it connects to something that Antonio also raised, which is the ability of tribunals to generate jurisprudence, right? For that jurisprudence to accumulate over time and for us to end up going in directions that may or may not have been anticipated in those treaties, whether those treaties be the old treaties in the 1960s or the new treaties that can include human rights or environmental obligations. So I think I think I agree, I guess, with Nicholas, that arbitral tribunals can be agents of legal development in the same way that we're more accustomed to thinking of courts as agents of legal development. I think that actually may be something that I'm not sure, maybe you know, Antonio, how that was kind of thought about in the 1960s. I think there was a clear, in some of the discussions that happened outside the drafted ICSID, but around the same time about, okay, so how do we resolve these investment disputes? Some state officials, but also just legal experts are saying, well, international investment law, it's so contested. If we create this court, we don't know where it's going to go. We don't know what direction it's going to take us. So why don't we just create arbitral tribunals? And that way there's sort of less scope for them to run away.
Yeah.
And I think there may still be that debate going on today, but that's probably outside the scope of what we're going to talk about today. I don't know, do you two have thoughts on that?
Well, one thought that occurs is that these concerns about whether the ICSID or similar mechanisms might invade regulatory space, or more broadly speaking, sovereignty, were very much on the minds of the negotiators of the ICSID Convention, and particularly these concerns were given very loud voice by the Latin American countries at the annual meetings of the World Bank, where the idea to move the ICSID initiative forward, where that decision was taken. And if you go to the collected documents on the ICSID history that's published by ICSID, you'll see right in one of the first documents presented there is an extract from the speech at the annual meetings in question in Tokyo, where the governor for Chile spoke very eloquently about these concerns, and in the context of explaining why all the Latin American members of the World Bank were voting against the initiative. So it's just to say it's not a new concern, and it is a problem that I think is most efficiently and inescapably addressed through the consent of the parties to arbitration. And, you can't expect a very broad, all-encompassing consent to exclude that sort of thing, but you can easily expect a well-crafted and suitably sort of sober consent agreement to do that. So I think that in a way it's not really an ICSID problem. The mechanism is there, and if you want to use it for all and sundry disputes, you'll get all and sundry disputes. Otherwise you should craft your consents more carefully. I think is the bottom line on that. Just very quickly mentioning Calvo, if you compare the statement given by the Chilean governor at the World Bank annual meetings in Tokyo in 1964, in 1964, with some of the remarks given by certain OECD member country observations about what's now called ISDS, it's very hard to distinguish the sentiments one from the other. And Taylor, in her book, quotes a couple of times our late lamented friend Thomas Velde, saying that the biggest adherents of the Calvo doctrine these days are in the industrial countries.
Yeah, I mean, I completely agree with those thoughts, and this I don't think this problem is specific to ICSID, and I think the whole idea that tribunals have this discretion, and their decisions could impede upon public policy and space that goes beyond just the legal decisions that are taken by states comes from the fact that a lot of these treaties are still very vague, and there is a lot of discretion left to the arbitrators. I mean, this is like a fill in the blanks. Which probably students in nursery or in grade 1 you have this you come across these exercises where words and phrases and terms are left open to fill out, and this is what arbitral tribunals do, and this is how the system is structured. But I think that with increasing awareness and with increasing thought about arbitral discretion, and a lot of states are actually trying to limit arbitral discretion, but there's only a certain limit to an extent to which you can limit it, because ultimately arbitrators are very, very clever people, and the lawyers who argue on both sides are very clever too. So whatever you may write in a treaty, there will always be that space for arbitral discretion and innovative legal arguments. So I don't think this is a very unique problem, but I do certainly think that states are actually thinking more. ICSID probably is thinking more. Other institutions are also thinking more about it and trying to limit arbitral discretion. But I think there's only to a certain point that you can limit it. I mean, obviously through consent, but what can you limit? Like you limit, like you probably put in a rule requiring exhaustion of local remedies, but you leave out like 10 other things. So there's only a certain limit to which you can do these things. But yeah, this is a valid concern, yes.
Exactly. Kostas Kostadinov has made some interesting points and wonders if the commentators have thoughts about the geopolitical and economic context, and if they could talk a little bit more about that. And he notes that the 1960s were turbulent times. There were a lot of things happening. We all know about the discussions ongoing at the United Nations, and whether you have any insights or thoughts about how the geopolitical thinking at the time actually motivated or helped to create the design of ICSID.
Would you like to start? Okay, I'll start.
I thought that's what your whole book was about.
I'll start and then you can correct me. So I think, absolutely. I think ICSID was designed in the way it was designed, and it sort of came about the way it came about because of the time in which it was created. And I think maybe the most obvious, but also most interesting example of this is these regional consultative conferences. I wish we could all go back and see the buildings that they were held in, and the optimism, because countries are newly independent for the first time, and so and Marcus has these great quotes, right, about we're going to take the show on the road. And where are you going to take it? You're going to take it to Santiago, you're going to take it to Addis, you're going to take it to Bangkok.
And Geneva.
And Geneva. Maybe not as new and exciting, and Geneva. And it's going to be held in these brand new UN Regional Commission buildings, and it's going to really tap into the optimism of not necessarily the non-aligned movement, but it's going to tap into the optimism of being independent, of not only political independence, but also economic independence, that this is going to provide a mechanism through which, and I'm not saying that it does, but through which maybe concession contracts could be peacefully renegotiated so that they are more equitable profit-sharing agreements, so that you will have money for core nation-building tasks and schools and roads and these things that were important to newly independent countries, but also other developing countries at the time. So I think the way that the idea of ICSID travels to capital importing government, it travels on a wave of optimism and enthusiasm about development that I think has been lost, or at least appears very differently today. I think it's also important on geopolitical context to note that the Soviets are not speaking in the discussions to draft the ICSID Convention, of course, right? They're not members of the World Bank at the time, and that makes it different from discussions that are happening in the UN, and it's sort of, if, say, this is the full spectrum of views, you're sort of getting this spectrum of views in the ICSID framing discussions.
Interesting.
Because that nationalization and those ideas are just not represented in the room. So I think that's one thing that makes it different from discussions in any kind of a UN forum at the time.
So Dinesh, any thoughts, or Antonio?
I think that's very interesting perspective, Taylor. I think on this, making practically the same point, but from a different angle. One thing to remember is that this was a time, the early 60s, not only of rapid decolonization, but of very heightened Cold War tensions between the Soviet bloc and the Western countries, in which the development of developing countries was an important strategic objective, and in that, in turn, because official aid budgets were stagnating at that time, gave an impetus to these various international initiatives to promote foreign investment to developing countries, international insurance for investments, code of conduct, and an arbitration agency. And so ICSID came out of that context. It is very interesting to read again this UN report that I keep talking about. You'll see that the first one is saying that the arbitration agency should be set up under UN auspices. So it would be a UN ICSID. And that, as I think Taylor has hinted, that idea didn't fly because there was, within the UN, there was too much opposition from a significant part of the UN membership, namely the Soviets and their allies, to this sort of activity, and that was an important reason for transferring the whole effort to the World Bank Group, where the Eastern Bloc countries were not represented. Just a quick point, speaking about this UN report, it surveys, as I said, the various options that were floating around in those times, including the code of conduct, substantive code of conduct. And the idea was definitely we can't go with this because it's too controversial. They're not going to get broad agreement on these substantive standards of treatment of foreign investment. But we can cut out the arbitration part and concentrate on that. And yesterday I was reading this new paper issued by this Columbia University Center for Sustainable Development. And it is saying, it's sort of rich in irony. It's saying, well, what we can do with these investment treaties is cut out the investor-state part, and we'll leave the substantive standards of treatment because everybody agrees on those now. It's such an ironical turn of events.
It's very true.
Yeah, I mean, broadly, I would agree with what Antonio and Taylor have said, and I think they're much more qualified to comment on the geopolitics part of it than me. But I would say that obviously, everybody wants to have this broader have this 20,000 feet view and look at everything in a very broad perspective. But I think things are a little more complex, and obviously they can Taylor and Antonio can correct me if I'm wrong, but I think this spread of ICSID and the spread of investment treaties is much more complex and much more dynamic to be truly and articulated in geopolitical terms. And I think it's more about the small efforts that probably the international officials working here at World Bank and the bureaucrats working in the small developing countries played, and those small efforts lead to the creation of this huge regime now. I mean, obviously you would want to view it and you would want to understand and analyze it in geopolitical terms, but I think those small things are equally important. And one of the things that immediately comes to mind is at some point in the book, I think Taylor mentions that a lot of the Commonwealth countries, the Commonwealth was created, I think, in the same year as ICSID. It was 1965 or 60, probably a year here and there. And immediately after creation of the Commonwealth, I think 19 out of the 30 countries immediately signed the convention, which is obviously, you can view it in geopolitical terms, but then you can also look at it in a different way and look at why, my own country, which is obviously a very large country and is an important member of the Commonwealth still, did not sign the convention. South Africa, which is again a huge, at that time it was under white minority rule and never signed ICSID. So, you would probably have to understand it. It's a little more complex, and then you come across these views which I did not know and which I have never seen, working in, Indian government officials, South African government officials saying that, the convention is going to give rise to public policy concerns, and this is going to take away, the role of domestic courts, some of the concerns which are still, valid and which are still expressed to this day. So it's a little more complex, although you can view it in those geopolitical terms, but then also you have these small stories and small, snippets that one should focus their attention on.
Exactly. One of the things that I found interesting, Taylor, was that you attributed a particular genius to Brokus by keeping the economists out of the room and by making this a legal process. And I think it's really especially kind of ironic because we see today a huge debate between economists about does FDI increase with investor state or with investor treaties, and what's the relationship and what's the cost benefit. And so I found that a very interesting thought. Do you think that's something that Brokus did intentionally or instinctively maybe? And did it make a difference?
So it's a really interesting point. And I am unsatisfied. Maybe you can help me with this, because Brokus knows a huge amount about facilitating investment flows, And at the OECD at that time, in the Development Assistance Committee of the OECD, there are really sophisticated studies on what do we think will facilitate investment and what is the development impact of different types of this investment. And they're trying to measure it with statistics and with surveys, and they're really in it. And Brockes knows about this, and he says, I'm reading the papers for this, is what he says, but yet he decides not to go down that road. He always couches his claims about facilitating investment relatively generally. And so he says things like, it will remove the impediments and thus we should expect investment to flow. I mean, it's a kind of an indirect phrasing, except for, I think, the report that accompanies the convention that goes to the executive directors, where it's phrased a little bit more directly. But any other time, he just says sort of, it must help.
Interesting.
And I think, I'm not sure, but I think he's being a very smart and savvy diplomat when he says that, because he doesn't want to get bogged down in impact studies and have the success or failure of his initiative rest on what somebody finds, right?
Yeah.
He just wants this machinery to be created, so he keeps it loose. The thing I think is almost more interesting is that governments keep it loose as well, right? Because it's one thing if you're the World Bank and you have all these member countries. It's another if you're signing a treaty with a country. You can measure before and after, you can do surveys, there's a lot you can do there. And yet governments, at least as far as I have seen, are not interested, or historically were not interested. I think this may be changing.
Yeah.
What do you think?
I think since reading your book, I tried to, I instinctively want to defend the bank. And what? We thought about that. No. I think much of what you say I completely agree with, and I don't disagree with anything you say, in fact, on that or anything else. But I think the part of the picture that I was trying to hint at before is that the bank and Brockes, they went into this with this background of support and studies from the investment community, and in terms of more wide-ranging studies from that UN study, which was heavily, or at least claimed to be, empirically based. So I mean, how much more could he do? And I think probably if you asked him, you would get an answer like the one you gave. It must help a little bit, and that's what the executive director's report on the ICSID convention basically says. It says, there are a lot of things you can do to attract foreign investment, and this might be a small part, but something, and every bit counts, that sort of thing. There was never a claim like, you sign this and you're just going to get, a rush of investment into your countries. There was never any claim like that. I think it was quite realistic and a sort of sober approach to it on the part of the bank and Brockes in particular.
One more quick comment on that, which is, I think it's interesting. This is why I like the comparison between insurance and arbitration at that point in time, because not only does Brockes say, well, we need to measure the impact of insurance, and I think that's in part because you pay up front, or someone pays up front with insurance, whereas there's not an upfront cost to arbitration. So people want to know they'll get their money's worth in a sense. But I think, at least my impression of this era and of officials in this era is that insurance is widely believed to facilitate investment, and sort of it's a concrete claim, whereas arbitration is always within kind of OECD governments, and the officials that really have a lot of information at their disposal are just leaving arbitration looser. So I think it's not just Brockes, it's others as well.
Interesting. You share that view, Sylvain?
I do, and I mean, obviously they would. I just read the book. I don't know the whole background, but one thing that comes clear to me from the book is, and Taylor mentioned it at the beginning of her presentation, is that Brock's personality was also very, very important in this, and his background, his family. I think, reading the book, I think he sincerely believed that arbitration is the ultimate way to peacefully solve disputes. He was, part of that school, which emerged out of World War II, never again, So I think that, and he did not think that he probably just thought as a lawyer, and, if I was him and I was in his place, probably I wouldn't think the role of the economist as important. And I don't think, and Antonio mentioned this, and I don't think he ever makes the explicit claim that, if you sign the convention, you would, get more foreign investment inflows, or you would, it will lead to economic development. I don't think he ever creates a very explicit link. Obviously it was a part of that package, but so was, changing your domestic laws, reforming your domestic laws. So I think that's there. But what I find interesting, in my experience, is that although Brockes was not an economist, a lot of the bureaucrats who actually, deal with these things in developing countries are economists, and it will be interesting to see why they made those decisions that they did, despite being economists. At least in my personal experience, a lot of the bureaucrats that I've met across Asia are economists, are MBAs. So they do have they are academically trained in economics, but they probably still did not think it necessary to do an econometric or an economic analysis behind doing these things. So I think that's probably much more interesting to analyze and look at.
A thought that just occurred to me, and I have the impression that back then the bank was not so compartmentalized as it is today in regard to professional disciplines. So that, for example, Brockes himself was the leader of the first survey mission of the bank to Nigeria, designing the lending program for that particular period for Nigeria. And so it's just a thought. I wonder if there would be so much turf consciousness then as there is now. What are you doing?
Apart from the economic rationale for ICSID, at least today we often hear a good governance rationale. And I wonder if you saw any evidence at the founding that this was one of the considerations, or is this something that's been glossed on in modern day practice?
Yeah. So I'll be interested to hear what you think. I think there's not as much of that that I've come across that emerges kind of as ICSID is being created. I think where that comes out maybe a little bit stronger is in the starting of some of the bilateral investment treaty programs. Particularly, I think the U.S. government has often, in earlier years, and I'm not sure if it still happens today, but seen investment treaty negotiations as a time to sort of teach about the types of property rights standards that they would want to see in the world. I know there's actually a fantastic new book by Mavluda Satarova that's just come out about governance and does investment law have an impact on host country governance. But in my view, it doesn't emerge as strongly in the early days.
What's the author's name?
I'll give it to you.
Oh, sorry. I'm a book fiend. It's a very small little observation, but during the regional consultations on the ICSID convention, as you mentioned, there were 4 of them in different parts of the world. All of these meetings were chaired by Aaron Brockes, And if you go through the drafting history, you'll see that at the beginning of each of them, he gave a speech. And if you compare the 4 different speeches, it's the same speech he has for his roadshow. And one of the points he makes is that this sort of mechanism can foster respect for the rule of law. So, I mean, he uses that phrase. So I think there was at least some consciousness of that aspect in it.
And I do think one thing I should raise, sorry, I should have had some answers. ICSID, very soon after it's created, embarks on this very ambitious domestic investment laws of the world, or it's called the Foreign Investment Laws of the World project, to catalog, but also in some ways survey and potentially have a kind of a very informal advisory role. And it's not just ICSID. ICSID is still sort of sitting within the World Bank legal department, so that's a little, it's I think officially, I'm not sure which one it's a project of. So those discussions are ongoing. And then that's very much about.
It was an ICSID project, but the personnel back then, they were sort of interchangeable to a degree. So I think the department can claim a little bit of credit.
And did you see anything that would further explain why the investment world went off into bilateral treaties, by and large, and yet the trade law world stuck with the multilateral approach, the GATT? And presumably you have fairly small bureaucracies dealing with different sides of the economic coin, and yet going in such different directions. And that's made a huge impact on where we are today. Did you see any reason for going in these different directions from the research?
It's funny, one thing that always struck me is I expected to find more, and maybe this is just how archives are organized, but the records that I found deal really only with investment.
Yeah.
And potentially it's because these are the officials who are then going to Paris to talk at the OECD, or they're going for a specific mission, and so that's how the papers are sorted. But it seems like it proceeded as a very different discussion. But I think one reason that makes sense on sort of the economics of it is foreign investment trade can be conducted, at least classically, sort of across the borders. Whereas foreign investment is behind the border. It's always going to be that little bit more intrusive. There's always going to be, I think, more sovereignty issues at play, or more domestic regulatory stuff that is just inherently part of it. So I think it, in some ways, makes sense that a multilateral process was possible for trade, where investment was, again, these North-North talks have never gone well, and I think that might be one reason why.
Yeah. So, Suresh, have you got any thoughts on this sort of bilateral versus multilateral, and in particular from a developing country perspective?
I do. I mean, it's very interesting that we in the investment treaty regime and the investment treaty world moved into this this network of thousands and thousands of treaties, and when you have trade at the WTO, but the interesting thing that I know from my research in a different context is that investment was actually supposed to be a part of WTO's agenda, and investment was supposed to be a part of this whole package that comes across that comes with ratification to the WTO, but this whole project was derailed, as Taylor rightly identified, because of the idea that in the WTO, when investment was included in one of the I think they were called the Singapore issues in the Singapore round. So when investment was included as a part of that package, the primary resistance to it was based on the fact that investment liberalization, investment under WTO, investment as a part of trade would mean that countries, and developing countries especially, have to liberalize their FDI regimes, have to open up their regimes, and they cannot change it sectorally, but they just have to do it like in one shot as a part of accession to the WTO regime. And the whole idea, and which is also probably borrowed, and which is also similar to the US model of negotiating treaties and the U.S. model BIT. But developing countries, I think, were particularly opposed to this idea, which is why the negotiations at WTO failed. It was never included after the Singapore round. And I think I have a quote here, which I thought of including it in my, opening remarks in some context, but I forgot. But I have a quote here from a minister. This is an Indian minister, this is from the Hong Kong Ministerial in 1999, and he says that, he's talking about why India does not agree and India rejects the idea of including investment in WTO negotiations. He says, investment treaties have found favor with developing countries because they do not place any restrictions on host countries in following their own FDI policies in light of each country's unique needs and circumstances. Generally, investment treaties aims at the protection and equitable treatment of FDI after the investment has taken place in consonance with the host country's laws. Thus, a developing country has the freedom to grant national treatment only in the post-establishment phase for investment, post-establishment, subject to qualifications as may be considered necessary. So I think this was the broad thought that, investment treaties was this sort of post-establishment benign. At that time, obviously, a lot of countries did not see themselves as respondents, but they were this sort of post-establishment benign, standard creating treaties which did not intrude upon the policy, the policy space that was available to governments to regulate. And the interesting fact here was that actually, this was derailed and, led by countries like Malaysia and Indonesia and, India. This was never included in the WTO, negotiations, and I think that's how it came to where we are.
Yeah. Interestingly, Brockus in many respects seems to have left what you might call the tough stuff for later on or for the tribunals.
Meg.
Probably the best one that we all know of is no one could figure out how to define investment, so it was, they'll figure it out. And there was all this room for exhaustion or not exhaustion. We'll figure it out, and exceptions to coverage. Was that brilliance or folly or somewhere between?
I think, just on the issue of meaning of investment, in the discussions with the member country representatives in the legal committee, they were really deadlocked on that point. There was a very strong view, principally among the developing country representatives, that there should be a definition, and an equally strong view the other way amongst principally the industrial country representatives, that it would be inviting problems. And that was one of the few issues that was kicked upstairs to the executive directors to break the deadlock on. So I think Brockus, what I derive from that whole episode is that Brockus was very wise not to try insist on getting that point out. He might have had no exit convention at all if he'd taken that approach to getting certain issues resolved.
Yeah.
So there's a really interesting episode, as Antonio says right there, extensive debates that happen in the drafting committee, and there's a recent article by Julian Mortensen, right, and he says, well, the British government, I think there was a British chairman of the relevant part of the committee.
He was the chairman of the drafting committee.
Chairman of the drafting committee. And so Mortensen sort of gives the British government kind of authorship over the eventual compromise, which is a non-definition, as we know. But then in the British archives one day I found this fascinating series of exchanges where the British government said, we're not sure what this means. Can we ask Brockus? And so the British government in London writes to someone at the embassy in Washington, and they say, can you go and speak with Brockus and ask him what what's included in this definition of investment, because we want to know, is portfolio investment included, are these things included? And then they go and speak with Brockus, and then they write back to London, and what they take away from Brockus is that any attempt to define investment would have made it more restrictive, and they think at the time that would have perhaps precluded ratification by people like Hickenlooper in the U.S. and things. And so in this definition of investment, we kind of have the whole approach in a nutshell. Keep the controversy out because we're trying to get the widest possible group to ratify.
Yeah. Another question that I've always wondered is this amending formula. I don't know if you came across historical information on this, but as many know, ICSID requires 100% approval to amend the convention. And that seems, let's just call it, a bit inflexible. I don't know that there's any other international organization that's got 100% requirement. Was that also part of being able to get the compromise and get the broadest group possible involved?
That is the story about that is in the discussions at the regional consultations in Santiago. So that's all the Western Hemisphere countries, the Latin Americans plus the United States. And the U.S. delegate who spoke on that issue was Andy Lowenfeld, who was then a young advisor in the State Department legal office. And the point was, if I remember correctly, the concern that was expressed on behalf of the U.S. by Lowenfeld was that we can't go into this and have a blank check that would then got to sign up to any subsequent changes. And I always thought that was not expressing the thought that voting on the amendment in ICSID would not be subject to the weighted voting system of the World Bank, where countries like the U.S. can very efficiently protect themselves from amendments they might not welcome by they have a veto, effectively. And I have the sense that this was an argument that was almost entirely put forward by the U.S. and carried because of U.S. concerns. One of the delegates in that discussion who made a strong pitch to have the convention somehow flexible was the longtime Solicitor General of Jamaica, Ken Rattray. And Rattray was saying, who later became an ICSID arbitrator, by the way, Rattray was saying, don't do this because then you will have a situation where just one country can veto any change, and you have what you have as a result. So.
Good. We always conclude these trying to bring ourselves up to today and what we're seeing today, and I think it fits very well. We've talked, and Suresh brought this point up very well, that the genius of Brockus, or maybe this flaw, was to separate the substantive and the procedural. And certainly that did allow ICSID to become established and get off the ground. But we now today see a very similar approach at the UNCITRAL Working Group 3, where it's clearly been established that the substance and substantive obligations are not at issue, and yet one of the key concerns is coherence of jurisprudence, which relates more to substance than anything else. So the question for the panelists is, will the Brockus approach and what worked with an ICSID be equally effective in the modern day context? I'm getting a lot of looks from panelists here.
It's a multi-billion-dollar question.
Exactly. You don't have to have conclusive answers. But it is, I think, an interesting difference. Yeah. What worked then may not or may be the answer today.
I do think it's really interesting that in, for instance, UNCITRAL meetings, right, EU member states will get up and say the lack of coherence, the incoherence, the lack of coherence, right? So this is a problem that's over and over and over repeated again. And the answer, as far as I can see from these governments, is a procedural solution.
Exactly. Get the same people to interpret.
Yes, and I'm not sure that, again, in my personal view, which doesn't, if coherence is what you're after, then surely stating the substantive law is the most straightforward solution to that problem. And so I think, not exactly the question you would ask, but it seems like if what countries are really interested in is coherence, then there's a lot that could be done potentially as part of the UNCITRAL process to maybe issue interpretive statements and say, these are the interpretations of FET that we want in our treaties, or this is what we want to apply across the board. I think that's very difficult work, but if coherence is what you're after, then if it's a court or if it's arbitral tribunals, if that's, say, a large opt-in multilateral interpretive statement, I think that's a relatively direct way of getting coherence.
Sure. Sudaresh, thoughts?
Oh, well, I mean, if I were to say just in one word, no. I don't think that, I mean, that's my personal view, but I don't think that it's going to be as successful separating substance from procedure and borrowing on from its idea is going to be successful in a different forum in this day and age, because simply because of the fact that I think that this is a very different era, this is a very different age, and I was there actually in New York for a day, in April when the negotiations were happening, and the House is extremely divided, and obviously everyone has their different, every state has their different views. But, even amongst, like-minded states or states that you would think would have, a similar strain of thought, you struggle to come across a consistency in views. Some states, obviously, you already pointed out the fact that some states think that coherence is the problem. Some states, like by the EU, think that it's the systemic, issues which are the main problem, that this is a closed world and this is like a privileged club and they want to increase the diversity of membership. So I think there is so much opinion even amongst states, and people are all unlike 1965 we have Twitter and we have Facebook and people are always writing and commenting, and there's just so much information available that I don't think that it's particularly easy for a huge for huge countries, for example, in Asia, to make those decisions that they were able to make in the 60s and the 70s. So I hope I hope they're able to do it, but I don't think that it's going to be, just because of the fact that we live in a different world.
Different world. Interesting. Antonio, what would your thoughts be?
I think it's pretty coherent, the jurisprudence. I don't really quite. I mean, sometimes it's almost monotonous. Anyway, that's what I think. I think it's quite coherent, and without wanting to sound complacent, I really wonder what the problem is.
That's great. I like Sudaresh, your analogy here. I'm just imagining Brockus on Twitter, and it kind of makes me feel a little bit better. But I wanted to thank all three of you for your comments. And Taylor, we know there are still many stories left in the archives, so we are very, very pleased that you're still working from this really unique angle, and we look forward to all the work that you're going to come forward with and to doing this again for your next book. And thank you very much for being here today. And we want to thank all of those people who have tuned in on the webinar. I know that one question in particular, Joey Zhu was asking a question about advice on how to prepare to enter the dispute settlement system, and I just wanted to say, not that we're going to ignore that today, but we're going to be doing a whole separate presentation on that at another point. So, Joey Zhu, I hope you will let us do this in greater detail in our next presentation. And what's left today is to thank our speakers from today. Thanks very much.
Thank you.